Unmute.
Okay, I'd like to welcome everyone this evening to a workshop on our draft solar ordinance, and ask the clerk for attendance.
Councilmember Hogan.
Here.
Councilmember Noonan.
Here.
Councilmember Donahue.
Here.
Supervisor Kuznir.
Here, and we're also joined by Town Attorney Carla Bittner. Hopefully we can, this will be our final evening in getting the draft ordinance in a shape that we can provide it to our planning board and zoning board for their input. And from there, then it will become a document for public consumption, and we'll move forward with that process. So I believe that the town attorney has provided all board members with a copy of the changes that we have discussed to date. And it's redlined in there, right? That's changed. And we do have some outstanding issues that we need to address, which include abandonment and decommissioning, penalties and severability, and then also a discussion on what the town would like to do regarding pilots on these projects. And then we'll have to provide direction to the town attorney as to whether the board wants to consider the overlay district or not. So with that, what would you like to pick up, Councilor?
Abandonment and decommissioning. That's 149, new 100, renumbered 100. This sets forth the abandonment and decommissioning for all tiers for their solar energy systems. You can go through it if you want to. It's basically from the model law with a couple minor changes. Ultimately, what you see is tier 1 and tier 2 are abandoned after a year without electrical generation. They have to be removed from the property. You remember that in the prior 3 sections, we talked about the 3 different tiers. We discussed the decommissioning plan that was required, and all of the requirements in the decommissioning plan are in the prior sections, so you won't find those in this section. So this just goes through when something is deemed abandoned, when it has to be decommissioned, and what the town can do. So that's what all of this is. So if you're looking for the other parts of it, it's already in the requirements for the application to be presented to the boards.
Right. So I believe all the board members have a copy of 149-100. So we can go through if you want. You know, it's a 2-part section. There's under A, tier 1 and tier 2 solar energy systems be deemed abandoned after 1 year without electrical generation for consumption, and they must be removed from the property. Removal must occur within 180 days of notification by the town building department to the owner. Applications for extensions are reviewed by the planning board for tier 2 solar energy systems, the building inspector for tier 1 solar energy systems, and can be extended for a period of 3 years. Does that work for everyone?
Yeah, I have a question. How would we determine if something is not producing or generating electricity or being consumed? How would we determine that? How do we know?
I think the building department keeps tabs on it.
Okay.
Throughout the process.
So there's like they go out once a month or once every couple months and determine.
Correct.
If these are still generating electricity, they're still. Okay. That's kind of one of those things where we wouldn't know.
Right.
Because they're out there.
Right.
Doing their thing.
We're not questioning that as far as going out and actually checking to see if they're producing electricity. I don't know how to do it.
So I guess that's one of the things that we would have to figure out on the town management side, I would imagine.
I don't know, I'm thinking more if you came across the house that, let's say it had a fire and now it's sitting there and solar panels are on that house. It's probably not producing electricity if the house is abandoned. That would be, so if the house is abandoned, the solar panels are abandoned. Should be removed within a certain period of time. Beyond that, I'm not sure how our building department will be able to check and see if they're actually producing electricity.
Well, I think, what this does is gives the town building department discretion to,
If something's in question?
Yes, to go out, and then it would be up to the property owner to.
I mean, I can see what, like, they could go out on National Grid or something.
Right.
National Grid would be able to tell them that they're producing electricity.
Right. Well, it'll show up in the utility bills too, right?
Yeah, the town doesn't have access to that, though, do they?
No, but I mean, as far as if it was called into question by a representative of the town, the property owner would just have to show, I don't know whether it's monthly or quarterly, I don't know how it would work with these rates that they're generating.
Is that something we can put into our law? That documentation has to be, if requested, has to be turned over to the town?
We can put that in there. I would almost think we'd rather do that by policy in the department.
Yeah, it'd probably be easier that way.
That's fine. I'm
Because
just,
it's easier to
whatever's
change.
the most best way to get it in there.
It's easier to change policy than it is to change a law.
Okay, is one easier to not have to live by than the other? Like, people don't follow policy all the time.
Well, it would be an internal policy. It would be a policy that you'd be directing the building department to go and do X.
Okay.
Yeah, but if a homeowner,
Then they're in violation of the law. Because the local law, the penalties of it fall under the zoning law, and the zoning law gives the building department the authority to go upon reasonable notice to speak to the folks and to inspect their property.
okay,
That's in the next section.
okay.
That's fine. All right.
So we're okay with A for the moment?
Yes.
All right, so B of that same section 149-100 refers to tier 3 solar energy systems and specifies that they shall be deemed abandoned if the system fails to generate and transmit electricity at a rate of more than 10% of its rated capacity over a continuous period of 1 year. A large-scale solar system also shall be deemed abandoned if following site plan approval, initial construction of the system has commenced and is not completed within 18 months of issuance of the first building permit for the project. And under section B, there's 3 subsections. Subsection 1 refers to extension of time. Time in which a tier 3 solar energy system shall be deemed abandoned may be extended by the planning board for an additional period of 1 year, provided the system owner presents to the board a viable plan outlining the steps and schedules for placing the system in service or back in service at no less than 80% of its rated capacity within the time period of the extension. Further says an application for an extension of time shall be made to the planning board by the tier 3 solar energy system owner prior to abandonment as defined herein. Extenuating circumstances as to why the tier 3 solar energy system has not been operated or why construction has not been completed may be considered by the board in determining whether to grant an extension. Under subsection 2, a tier 3 solar energy system that has been deemed abandoned shall be decommissioned and removed as part of the decommissioning plan. The decommissioning plan must be completed within 360 days of notification by the building department to the owner of the tier 3 solar energy system. And finally, section 3, if the owner and or operator fails to comply with decommissioning upon any abandonment, the town may, at its discretion, utilize a bond and or security for the removal of the tier 3 solar energy system and restoration of the site in accordance with the decommissioning plan. Anyway.
My question. Yeah, so in B, the first paragraph, at a rate of more than 10% of its rated capacity, Okay, so its rated capacity might be 50 megawatts, I don't know, megawatts. And we're saying that if it's 5 megawatts, it's no longer active. Is that correct? Am I thinking along that way? Because when I first read it, I was like 10% of its rated capacity over a continuous period of 1 year. 10% of its rated capacity. We're saying that the output on this has come down so far that it's not really producing more electricity.
Correct.
Okay, got it. No, that's fine now.
I'm fine with that. Again, just would like, I'm sure it's gonna be later on, to know what these outputs are at some point with these, you know, I say we town, the building department, or whomever is following up on these numbers. That's all. So
All right, so we will move on to 149, 101, penalties. Penalties for offenses specifies any violation of the solar energy article shall be subject to the same civil and criminal penalties provided for in the zoning regulations of the town of Monroe. So basically that gives this board and future boards flexibility based on whatever our policy is for penalties. Or is that
the law in your zoning code, because this is part of the zoning code.
So it refers to.
It refers to the penalties and the fines in the zoning code. Instead of having different ones, these are in one code.
So we'd be uniform in what we already have established.
Right.
Good enough.
fine with that.
And then severability, 149-102 specifies the invalidity or unenforceability of any section, subsection, paragraph, sentence, clause, provision, or phrase of the aforementioned sections as declared by the valid judgment of any court of competent jurisdiction to be unconstitutional, shall not affect the validity or enforceability of any other section, subsection, paragraph, sentence, clause, provision, or phrase, which shall remain in full force and effect. And that's pretty much standard language.
That's standard.
Yeah.
It says if one of the sections is found unconstitutional or is violative of any law, then it doesn't violate the entire part.
All right. So that's sections 100, 101, and 102 of 149. Which takes us to payment in lieu of taxes or pilots. And this is the verbiage here is pretty much boilerplate from what we gleaned from the NYSERDA's
Correct.
draft.
Correct. This is based on the model law, a couple changes.
Yeah, that's what's yellow up in here.
Yeah, well, yes, the yellow part, and Leah and I spent about an hour this afternoon talking about this, Leah Cronin. Because we wanted to make sure the board understood the purpose of this, so that the board can, so that we can get actual dollar, they're not tax dollars or payments instead of tax dollars. The town can actually recoup additional funds above and beyond the tax dollars. Because what you're doing is you're giving them a tax exemption, but in order for them to get a tax exemption, they have to enter into a pilot agreement. So this just goes through and tells, you know, under the real property tax law, what they have to do in order to enter into the pilot agreement, what has to be in the agreement. The agreement will be negotiated between the supervisor and the solar company. This is only for tier 3s. And this is something that is done around the state. It's something allowed under real property tax law. Saratoga County does this. They have their own law. The school district could do this by resolution. They have not yet. The village could do this as well, but I don't know as if they have any room in the village for a tier 3 in any event. So it goes through, and I'm happy to go through and explain it, but it says what has to be in the pilot agreement. It's fairly innocuous. The one thing I want to bring to your attention is, and I didn't have numbers in it, but if you look to the contents of the pilot agreement, and if you go down and look where it is highlighted, the annual payment portion of it. So there's two things you could do as a board. You could identify, as it's set up here, you could identify in the actual law how much you want to charge per megawatt, and then what the escalation would be per year. Some municipalities do that, some do not. Saratoga County does it, Clifton Park does not do that. The other thing you could do is, instead of assigning a payment per megawatt for any of these tier 3s that come in, you could simply say that the annual payment will be negotiated. And then each agreement, you're negotiating a different amount. That's completely up to the board. It's 6 to 1, half a dozen to the other. Leah and I spoke, there's not one better way to do it. It would be easier if the number was in here. Obviously, then we have, this is what the pilot agreement is, this is what the amount's going to be, and the solar companies would know upfront this is how much they would have to pay for pilot. So you could do that, or if you wanted to negotiate it and perhaps get a better amount for the town, you could just have a negotiation portion in there. So that's something I wanted you folks to know about, and to maybe give me some ideas of what you would like to do, or what you want to talk about, how you would go about doing that.
So there's essentially two schools of thought on that. I mean, if we have the numbers in there, any developers that are interested in looking at the town of Monroe for the projects, they're going to know right away up front what their hard costs are going to be, and have that as part of their evaluation process. The other side of the coin is it's negotiated with the town, and it gives the town flexibility, but it also is more time consuming. I mean, that means that these projects will have to become a town, did you say supervisor or town board?
The supervisor would negotiate it, and then
okay, the town board has to ratify it. So the town board becomes involved on the cost on every single one of these. I don't know, I didn't have a chance, I was looking today just to see what kind of ranges there were for costs. I don't know if you found that.
So the way it works, NYSERDA has a list, and they strongly recommend certain prices. And for example, if you go with National Grid, what it would be around here, NYSERDA said, they can only be burdened with a tax payment from all of the taxing jurisdictions on a range from between $1,700 and $5,100 per megawatt. That's for all of the taxing jurisdictions. The county in their law has that they get 1,000 of that right now. So right now you're bumped down to $700 to $4,100. Now you can put more in your code, that's fine. We would have to have a reasonable basis to doing that, and that would require us to perhaps go and review income expense statements of certain solar companies to kind of come up with this. I don't know if the town is able to do something like that. I know I cannot do something like that. So most municipalities adopt what NYSERDA strongly recommends. I think the terminology is highly suggests. So you might want to think about, you put whatever number in there you want to, but it's also whatever is with the rest of it. So what would the school get out of this? So maybe a conversation with the school, conversation with the county. I don't think the village would be involved, but a conversation with the village. Because collectively, this area, you can't get more than 5,100 per megawatt.
Right. And if, as you know, the school district will get the greatest piece of the pie.
It's not necessarily. I mean, it's thinking for taxes.
Yeah, but wouldn't there be a similar ratio for this?
No, because they're different pilot agreements. It's not like an IEA.
So you can say, county gets 1,000 out of that 5,100, which actually the county reduced it. It was higher than that.
And it's 3,500.
It was 3,500, and the supervisors very much wanted that number reduced so that the localities would have access to a larger number of that, a greater portion of that number. So then we could do, so does the school district have to agree to that number, or we set the number for the school district?
No, the school district is separate apart. So the school district, if they chose to do this,
Yeah.
they would have to do their own pilot and they would put a number in. So
But that would come out of that total 5,100.
theoretically, yes, because it's highly suggested that they're only entitled to 5,100. So I don't know if a conversation wants to be had. I don't know if we want to put something in there now as a placeholder to go through the conversation with the public. That's up to you.
I mean, I'd be willing to work with numbers that are kind of already established and then to get something in and then take a little bit more time, I guess, on my end to research so I would feel more comfortable with the number. But if there's numbers that are already in nicer, like you said, nicer that already has numbers.
Correct.
Maybe it's worth my thoughts, I guess, only choosing something that, because they wouldn't put just numbers in randomly, there's a reason behind numbers.
They have gone through and done the analysis.
Right.
Correct.
I think they're more educated on it than I am, so I do want to trust their numbers. I just don't know what numbers they would be.
Well, that's the thing, it's, right now it's 1,700 to 5,100 per megawatt.
Do they say where geographically or what companies are?
National Grid, that's National Grid numbers.
Our service area, yeah.
Right.
Yeah. Oh,
It's by service area.
so, all right, and this is my advice to the town.
Correct, which made for the town.
So basically, we're looking at 700 to 4,100 because the county's getting 1,000.
Correct, and it's up to the, yes, correct.
So,
So it's negotiable after a certain amount of time. Like say we put a number in this high, can we go back and change it in a year?
If you change the local law.
do we want to put it in the local law? Do we do it? I think you do.
That's my question to you.
Okay, so I would prefer to have general language that says there shall be an annual payment as determined by the town board. And so then we have a separate resolution on that can be changed by any board. And don't you think it's a lot cleaner that way?
Well, so then they're negotiating on each and every solar system, aren't you?
No,
Well, no.
I think it would be kind of like a fee schedule.
Yeah, like a fee schedule, like we do for building permits.
And what I think the point to doing that would be, just like in your water law or your the building code, it says, the fees will be as set by the board by resolution.
Right.
And each year, the board says, okay, the fees per megawatt would be this. Now, that would be for new ones. Obviously, you're bound for 15 years.
15.
Right, so if you're having 4,100 this year and 7,000 the next year, contracts at 4,100. So you don't need to change that, it's just for new ones coming in.
And what you said about the county, they get $1,000 per megawatt.
Per megawatt, right?
What would the board like to do?
I would like to do what you suggested, though.
So why don't we have general language in there, if you guys are okay with that?
I could open it.
And then we will set that, I don't know, who we set at the annual meeting or
I would do that at the organization.
organization meeting, yeah, so we could do that every year.
Okay, yeah. That sounds good and it doesn't impact future boards.
Right.
Okay.
And within that policy, we could have the escalation percentage in that
Absolutely.
policy. And do we have to spell out that there's going to be an escalator, or we just make that?
That would be the policy.
All right, so we'll take that out.
Well, in the resolution.
Yeah.
Yeah, so I took out 1 and 2, so right now it just says that the annual payment shall be set per resolution by the town board of the organization.
That worked perfectly.
Mhm.
And that was the only thing we had for open discussion under pilots, right? Or there was something?
Yes, no, that's it. I just was here to anchor.
Yeah, I'm not gonna, unless the board wants me to read it, you know, it's standard pilot language. Definitions are standard. I mean, I will read it in the record if the board wants to. You know, this will be provided to the public as part of the draft.
Right, and I think I'm gonna put it in, I think the best place to put it is right after we go through the abandonment and decommissioning. So it'll turn into section 101, and then we'll just make penalties 102 instead of 103. I think that's the best place to put it, unless someone else has a.
All right, we should be, as we get to the public hearing process, though, we should have an idea where we want to be for setting that number. So that'll give us time to come up with a number. We can offer it during the public hearing discussion when we get to that point. People are questioning it. That'll give us time to, you know, mull over where you want to be with the numbers, knowing that the county's going to be $1,000. All right. Okay, so that's pilot, and so I think the last issue is the overlay district concept for the tier 3s, which are your large commercial arrays. Do you want to reiterate just for the board the concept of the overlay?
The overlay district will allow the board to determine where in the town to have tier 3s and not limit it to specific presently existing zoning districts. It'll allow you to either say the entire town, there's an overlay district over the entire town, which means anywhere in the town, as long as you meet all of the requirements of the tier 3s and go through the planning process, you can have it. So it's not limited to just your M1, M2, and R5 zones. So it allows a little bit more flexibility for some of your larger land portions in R3 zones and in any other zones that might have a larger land portion. That's the benefit of having it as an overlay district. That's up to you. If the town board wants to do that, I'm happy to do that. The detriment is you're taking it out of just those 3 districts.
With an overlay district in place, because we have different restrictions currently in our draft proposal, would that supersede any limitations that we have in there?
Yeah, what you've already, all the work you've already done would basically become the overlay district.
I'll say that again.
All the work that you've done in the tier 3, all the things you're required to do, all the different amount, the slot sizes and things like that, that's going to be part of the district. So you're not going to be bound by the R5 zoning, you'll be bound by.
Right, but for instance, if we have limitations in the R5, like soil types, will this allow greater availability of land, or does it still have to meet the requirements?
That's up to you. We can make it so that it does not have to meet that. Right now, the tier 3 portion says specifically because of the agricultural uses in R5, that's where you have to look at that specific portion. If you're closer to that portion for your prime farmland. You can say, you can still limit that to the R5, but you may have prime farmland in R3 districts. So the question is, do you want to protect it in R3 as well?
Right, but the R3 zone is outside the ag district, so it's kind of, from my perspective, it's kind of a moot point.
It can be however you want to write it.
Right.
So another way to look at this too, if we do an overlay district and it turns out there's a significant amount of area in one of the residential zones where it's currently not allowed because there's a significant amount of space and the system goes in because it fits the requirements, but then in 15 years someone buys all the property around it and puts houses in, they could potentially be just looking at a project, right? We could put something in. I know that's like a what if. I'm just throwing it out there. I'm not sold on this, but it's an idea that, I don't even know if it's possible in R1. I don't think there's enough land in R1 anyways right now, looking on a map.
How about, I'm sorry.
You know what I'm saying, though, like if we did something where we allowed a tier 3 to go in, and then in 15 years, housing development opens up next door, have we shot ourselves in the foot by trying to protect the idea of a residential neighborhood about having these things because we allowed it today? We didn't think down the road that we're into something here that maybe we can't get out of. You know, maybe that can't even happen. Maybe there's nothing where that can happen. It's just a thought.
So you could do like a hybrid overlay district. In other words, it only applies to certain zoned areas, like R3 or
You
R2.
create the district. I used to say townwide, but if you want to say, we as town board think that the overlay district should be R5, M1, M2, and this area over here, you create the districts that way.
So one of the issues that came up as we went through the process with the different zoning areas was, like in R3, there are some significant like land holdings, multiple, 100, 200 acres. The way that our draft is right now, I don't think we allow tier 3s in the R3s. Is that accurate?
That's correct.
Okay. So would an overlay provide flexibility if certain standards were met?
The overlay, that's exactly the point. It provides the flexibility. Right now, if there was projects in the R3, it couldn't come because, well, let's say this was adopted as is, and you only had R5 and R1 and 2. And a project came in R3 and said, look, I got a great project, I have the land, can I put it there? The answer is no. You have to either get a use variance, or you have to do a PUD, and it may meet the PUD and it may not. That's the only way you can do that. Having an overlay, they could, and if that project was in the overlay district, they still have to meet all the requirements that's in 149.99.
Good. So could you attach, like when you say, let's say we allow overlay in your R3, can you have language that says if the project would be proposed to be located on parcels of 50 acres or greater? I mean, can you tie it in like that or not necessarily?
Well, right now your tier 3 is only 10 acres, I remember. So you're basically. Yeah,
I was just using that as an example though, but I mean, you can put a number on it though, right?
You could put a number on it, sure.
I don't know.
I did reach out to NYSERDA on this, and there are a couple of municipalities that do have overlay districts, so this is not something that's.
It's not very common.
It's not common, but it was a thought that actually Jim Martin and I had been talking. It was a thought we had when you folks had a conversation a few meetings ago saying, well, what about all these other areas that may have larger, they're precluded because they're not in this zone. This is just a way to encompass those folks. You don't have to do it. I mean, those folks would have the opportunity to try and get a use variance or try and come with a PUD. It doesn't foreclose them from requesting. It just doesn't give them the immediate right.
And I think from my perspective, at least out of the gate, I'd be inclined to go with what we have now, not go with an overlay district, because there are options available, especially for variances, PUD, and areas where we're not allowing it by zoning. And I think it gives our proposal more teeth, so say for like the R5, the R4 zones. If you do an overlay, that everything that we went through from beginning to tonight, we had all these requirements in there, but now we're also saying, but you can do this in there even though zoning doesn't allow it because we have an overlay district.
And you can use what you've already done. What I'm saying is everything that you've got in your tier 3 area, what you would say is this is allowed in the R5, M1, M2, and overlay. It's just adding another district onto there. So you would be creating all new requirements.
I think what I'd like to do is, get this to the public, make them aware of that option, have them weigh in during the public hearing, say if that's what they want.
Because I wonder if we say, okay, let's do an overlay, but let's chisel it to what we want. Would we find that what we chiseled it to was still what we already had before?
Well, that's what I was wondering.
Yeah, right. I mean, it's like, because my initial thought last time around when I said, hey, let's think about the overlay, I like the idea, it's less restrictive. But now we've had time to think about it, and I know in my mind, it's like, right, there should be some restrictions where we don't want to cause something down the road that's not favorable, and we start to put criteria on the overlay. Are we getting back to the original idea of the zone districts? So I would be willing to maybe scrap the thought of an overlay for now, with the public hearing. If the public is aware that there's another option to discuss that, I'm fine for that for now.
Okay. Well, no, so I'm just thinking that like with the overlay, some of the concerns that you had, wouldn't they be covered in the screening and landscaping of the plan? So that you, housing development that might go in next to a solar plot, is not going to be seen because of the landscaping that was put in at the time of the solar panels were in. You know, it's kind of like a moot point at that point. But you know, as far as the overlay goes, I can go either way. I mean, we're going on without having it in an R3 or R4 district. I'm okay keeping it that way. Knowing that it's available, if there's people out there that are really, you know, who really want to put in this area, that's fine. I never really thought that we wanted an R3 district. So as far as going with the overlay on that, I would go along with what you're saying.
Like I see a need for an overlay. We've set it up and set the districts we want them in. There's other avenues, like you said, for people in those districts that are included in this law. There's other avenues they can take, PUD, and stuff like that. Let them go through that process.
Okay, so now we'll tighten that. So that's the overlay district concept. Was there anything else that we needed to?
That's it. You folks have worked very hard.
It has been a long process. So now we've got it to where town board is conceptually on board with it. So now we need to get informed for public or planning board and zoning board.
Right. So what I will do, you all have the red line copies. I'm gonna accept all those changes and make that the clean copy that's going to the zoning board and to the planning board. The planning board's meeting, we are hoping to have it at the meeting this month, but there are 6 projects. So I'm thinking it's gonna be a January's meeting to discuss it. So probably January, we'll give it to them now, we'll give them plenty of time to look at it for their January meetings, and then they can come back and go back to you for any comments. Maybe we'll lead another workshop in January after they looked at it to address any comments, and then we can go out to the public.
So do we have to have the county weigh in on it, or does that happen after the public?
That's at the time of public hearing.
After the public hearing.
That's, no, not after the public hearing, that's at the same
Okay, so
time
we
as the
did-
public hearing.
Okay, all right, good. All right, anything else on the draft ordinance?
One thing I do want to bring to your attention that we spoke about last time, that I reached out to Matt in the building department about the roof mounted and how far away they were supposed to be up, and the fire separation question. I did talk to him, he gave me the code information, the building code, the IC information, and so that's now in here. It tells you how it's going to be. I want
There
to.
was, yes, there was something that I read that I was questioning, and it had to do with to be installed parallel to a roof, but not more than 18 inches
Right, we talked about that last time.
Right, but here, and what occurred to me was, you don't really want to parallel the flat roof, do you? You might want to.
That's a different section.
But that's covered.
Correct.
Okay.
Yes.
So then when somebody like Matt looks at it and says, okay, we're installing this on a flat roof, but we can raise it this much to get the better angle.
That's all in there. And it has to, and we put in there that it has to be, listed, UL listed, and, identify, per the instructions of the manufacturer.
Okay.
One other item, and I don't know if this has to be part of this evening's conversation. You and I talked, I have been researching what other townships are doing in the county, how they handle the permitting process as far as a fee schedule. And like, for instance, the city of Saratoga Springs has a building permit fee of $125 for residential, $300 for commercial, plus 25 cents per square foot. Clifton Park has our unified solar permit for residential fees, 75, commercial fees, $350. Milton is $250 for a solar permit. Half Moon is $150. We don't have to have that as part of this ordinance. We can do that as part of our fee schedule, right?
Correct.
Okay.
Yeah. They, when they apply for it, just like they apply for anything in the building department, you have to pay.
Good. All right. Anything else on for this evening? If not, we'll close the workshop this evening, and we will resume in 15 minutes for the regular town board.
I just gotta pause the recording. On to the video, and we are.
Okay, we're going to get started at 7 p.m. I'd like to welcome everyone to a regular Monroe Town Board meeting for December 8th of 2020, and ask the clerk for a roll call.
Councilmember Hogan.
Here.
Councilmember Noonan.
Here.
Councilmember Donahue.
Here.
Supervisor Kuzniers.
Here, and also note for the record that we do have a town attorney, Carla Bittner, with us, obviously the town clerk. And would everyone please rise for a pledge of allegiance? I pledge allegiance to the flag of the United States of America and to the republic
which stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. Item 1 is approval of minutes this evening. All the board members had a chance to review the minutes for November 18th, which was the town board solar workshop. And then we had 2 sets for November 24th, 2020. The first being the audit meeting for the end of the month, and the other the following regular town board meeting. Everybody had a chance to review those?
Make a motion to accept those.
Second.
All in favor?
Aye.
Opposed? Motion carries unanimously. Thank you. The next item is to set future meetings and workshops. We're continuing to work through the easements as part of our, securing the easements as part of our sewer project for commercial quarter, as well as some parcels on Bluebird Road. And we're to the stage now where I think we have approximately 8 or 9 outstanding parcels that we have been unsuccessful in securing those easements, which has required us to take the next step and commence eminent domain proceedings, which will require a public hearing on that process. So if the board would like to continue to move move forward in securing those easements, that is the next step. And the board chooses, that will require that we establish a public hearing on that process for January 4, 2021 at 7 p.m. here at the Town of Monroe. Everybody want to move forward with that?
Yes.
All right, so I believe the clerk has a resolution for the record.
Whereas on June 26, 2018, the Town of Monroe Town Board approved the creation of Sewer District Number 1, Extension Number 5, subject to the approval of the Office of the State Comptroller. And whereas on April 9, 2019, the Office of the State Comptroller approved the creation of Sewer District Number 1, Extension 5, at a cost not to exceed $60 million. And whereas on May 7, 2019, prior resolution adopted by the Town Board of the Town of Monroe on June 26, 2018, and subsequently approved by the Office of the State Comptroller on April 9, 2019, was filed in the Saratoga County Clerk's Office, a copy of which is attached here to and made part of hereof. And whereas in connection with the formation of Sewer District Number 1, Extension Number 5, certain sewer mains and other associated infrastructure need to be installed on real property owned by private citizens and located within the geographic boundaries of Sewer District Number 1, Extension Number 5, and is more specifically set forth in the notice of public hearing. And whereas in connection with the acquisition of certain easements for the installation of sewer mains and other associated infrastructure required for the formation of Sewer District Number 1, Extension Number 5, the Town of Monroe will conduct a public hearing on January 4th, 2021, at 7:05 p.m. at the Monroe Town Complex, 351 Reynolds Road, Monroe, New York 12828, in accordance with Section 202 of the Eminent Domain Procedure Law. Such public hearing to be held via video conferencing as permitted by the New York State Open Meetings Law and Executive Order 202.1 and all extensions. Now therefore it is resolved that the Town Board of the Town of Monroe will conduct a public hearing on January 4th, 2021 at 7 p.m. at the Monroe Town Complex, 351 Reynolds Road, Monroe, New York 12828, to describe the purpose for the installation of sewer mains and other associated infrastructure, the proposed location of the sewer mains and other associated infrastructure, and whether any other proposed locations exist for the installation of the aforesaid mains and other associated infrastructure. And it is further resolved, the notice of the public hearing, a copy of which is attached hereto and made a part thereof, must be published in at least 5 successive issues of the town's official daily newspaper, at least 10, but no more than 30 days prior to the scheduled public hearing date of January 4th, 2021, and shall be served either by personal service or certified mail return receipt requested to each assessment record billing owner or his or her attorney of record.
Thank you, Leanne. Would somebody like to move that resolution?
So moved.
Second.
Any discussion?
To be clear, how much, not, I guess more for the public, about how much property from the edge of the road, I guess, are we seeking for these easements?
I don't know what it varies. I can tell you that this is actually a twofold process. We are securing utility easements, not just a sewer easement. And the purpose for that is that for whatever reason, previous administration, when establishing the water district, did not secure easements for the existing water line that is in the ground. So we're cleaning up everything with this process. You know, the thing is that a majority of work is going to be done by directional drilling. So there's not going to be a lot of surface area disturbed. Right. But there are some that, although we have been working with them, they keep moving the goal line, so to speak, and getting approvals. So we've gotten to the point in the process where if we're going to get this project done on a construction schedule that we have all been anticipating, we have no other choice than to move forward with the eminent domain proceedings.
I appreciate that. I was just looking for clarification because don't need this to, I don't believe this is the town is gonna come by and take all this property.
Right.
Quite frankly, like I said, it's gonna be all underground across essentially the front, if you could, some of property owned by a private, individual.
Yeah, and just to be clear, you know, we have been, the town, and we didn't have to do this, but the town has been paying for all the easements that we have secured,
Right.
which is not, I don't think that's customary everywhere in New York State. But, you know, this board, it was clear from the beginning, you know, we wanted to work with the landowners. We had the ability to provide fair compensation for securing those easements. I mean, obviously the landowner still has the ability to have access to the property. It's not a lot of space. And you know, we're all respectful of property rights. But you know, this is a project that is for the good of the public, and because of that, we don't have any options to move forward. Now, I will add that an eminent domain proceeding doesn't mean they're not going to get paid for it.
Well, that's what I was going next.
They are going to get paid for it. It's just that it'll be a court process instead of a town process.
Right. I'm glad you put that part in. That was my next question. So to be clear, we're still paying for this property. We're not
They're being compensated.
I just think there's so much misconception about eminent domain that governments just take the property. Well, that's not what we're doing. We are still paying for it.
And I would just add that the property owners have been incredibly receptive, responsive, and helpful through this whole process. I think, you know, I can't even tell you how many 90 parcels are involved, maybe even more, between what's, oh no, there's 93 in the district.
Right.
So, and then we've had to do along the outside of the district too. So we've had a fantastic response from the landowners, very much willing and supportive of the project. And you know, I got to tell them, you know, I have to say for the record, I appreciate their willingness to work with the town on this project. So it's a very small number that we have to corral and get on board. So any other questions, comments, discussion, resolution? Council, do you have anything to add at this time?
I don't.
All right. All in favor?
Yes.
Opposed? Motion carries unanimously. Item 3 on the agenda is a COVID-19 update. Unfortunately, the numbers aren't as rosy as they once were, not only locally, but statewide and nationally. I can tell you that as of this evening, the most recent information that I have available, starting at the state level, I can tell you that the governor has directed the State Department of Health to begin implementing a surge and flex hospital protocol, which includes mandating that hospitals expand their capacity by 25%. Regions are to be designated as red zones if hospital capacity is projected to become critical. Indoor dining is going to be closed in New York City and reduced to 25%. In the rest of the state and the region, hospitalizations do not stabilize over the next 5 days. Presently, there's 4,602 patients hospitalized statewide. 872 of those patients are in the ICU, with 477 that are intubated. The statewide positivity rate is currently 4.79%, and there were 80 COVID deaths here in New York as of yesterday. Here a little bit closer to home, in Saratoga County, there have been 2,861 confirmed cases. The number of deaths has ticked up at least, I believe, by one since the last time I reported, to 25. The number of active cases in the county stands at 892. Total number of recovered individuals is currently 1,944. Presently, 15 individuals are hospitalized. And that was as of 5 p.m. this evening. So the 7-day rolling average testing positivity rate here in the county is 4.6%. The new cases in the last 7 days is 575. The new cases over the weekend is 247, and the new cases in the last 24 hours is 58. Here in the town of Monroe, there are a total confirmed number of cases of 82. There has been 1 death to date. Number of active cases 11, and 70 individuals have recovered. A little further up the road in the village of South Glens Falls, total number of confirmed cases stands at 32. There have been 0 deaths. Number of active cases is 7, and the total number of recovered individuals stands at 25. And also, just wanted to report, the governor has extended Executive Order 202.79, which provides for the suspension of the open meetings law requirements for in-person meetings through January 1st of 2021. Following up with item 4 on the agenda, I have listed as a municipal pandemic plan. Last September, I know that I reported the governor has required that all local governments put in place or establish a pandemic plan. The deadline for having that plan in place, I believe it must be provided to the unions by February 4th. And the municipalities must adopt those plans by April 1st. I can tell you that they're very detail oriented, they're extensive in their preparation, and essentially requires professionals to do that. We have, I think board members have a copy of a proposal from the law firm for the town to assist us in that process. I can tell you that typical rates for plan preparations are in the neighborhood of $8,000 to $10,000. Our firm is willing to put that together for us for $5,000. I don't know if council, you want to talk in greater detail about what the plan is going to entail and what we have to do?
Sure, I can do that. The plan basically is roughly 20 pages, and it is everything that you have been trying to do reactionary for the past 9 months. This is more a offensive approach in the event next year something happens or the year after. It lists who your essential employees are going to be. It lists what your remote work requirements are going to be. It goes through how you're going to close, how you're going to sanitize, how you're going to do it perfectly. All the leave requirements, everything that you've been grappling with for the past 9 months is going to be incorporated into a pandemic plan under the labor law. The state and all public employers and school districts have to put this together. We're doing it for a lot of our clients. They're all a little different because the state is different than the towns are different than the school districts. But it is something that has to be done, has to be provided to the unions for them to review in February. They review it and they come back and provide comments. And then it has to be approved by April 1st, reported to the state that it's approved by April 1st, on file here. And then the state DOL is actually going to have a portal open for people to put in violation notices or complaints if you're not following your plan. So it's something that if it had been in place beforehand, would have been a lot easier for the past 9 months. So now we're trying to think proactively.
Right. And to be clear, so there's no confusion, municipalities and organizations were required to put together reopening plans, and this is totally separate from that. It's a lot more extensive, more detailed. We do have a reopening plan here on file, and that we do require that of our organizations that utilize our recreation facilities.
And that's part of it also is because you have the rec park and you invite the public there, you'll have conversations with the public and be able, conversations perhaps with your emergency services, conversations with the school district, and how to put together this plan.
So we don't have to take action on tonight, but it's something that we should probably take up either before the end of the year or certainly in the beginning of 2021.
I think it's something that the sooner the better, because you will have to have it together into the next 2 months.
Okay, so it's the board's pleasure whether you want to move forward on that this evening. I do not have, as is typical, I provide where the money's coming from and where the money's coming from and so we can take action on it this evening or do it at a later date. I have no problem providing where the money will come from. If you want to take action tonight, we can do it at the end of the month meeting, whatever the board's pleasure is.
So sooner rather than later is your suggestion? So what do we have to do to take action tonight?
So we would have to authorize an addendum to the contract for legal services to the town from the Office of Barlow Ponds and Stewart Roads, PC, by an amount of $5,000.
We need to move that.
We need to move that.
So moved.
Second.
Any discussion? All in favor?
Aye.
Any opposed? I'm sorry.
Where's the money coming from?
Legal services. So we're deducting their cost of their contract by $5,000 for 2021.
I'll get it done for 2021.
So it'll come out of legal services. I'll get you the account number on that for everybody's, for the record and for everybody's viewing. So we're okay with that, and you move forward with that account number?
Yeah, I can put together the amendment and send it over to you.
Okay, great, thank you. Item 5 on the agenda, I have listed as transfer station, just a couple of brief items. First one is, and I'll let Council Member Hogan just talk briefly about the pump that we had an issue with, potential issue with today.
So it was discovered just this morning that there was an issue with some pump that was just installed, that because of this location and because of the problem with it, we need to get the installer back. We believe that the discharge tube is leaking, and because it's in confined space and they have a certification for working in confined space, they probably will be the ones needing to address it. With the company's solution, and I believe your office will be able to contact them and get somebody back to work on it.
Just want to keep everybody updated on that.
Do you want Ted's planning on leaving, and that we really should be looking at getting somebody there to cover and work in full-time capacity of running the transfer station.
Okay. Yeah, I think, we've gotten to the point now, especially since we've, ramped up our hours back to what they used to be. We're not doing partial days anymore. There's a lot of activity down there, and I think we're back to the point in time where you have to have somebody that basically oversees the day-to-day operations down there. And especially with, if we're going to be losing staff. So, maybe do you want to run an ad, or how do you want to handle that at this time?
Well, I'm thinking an ad would probably be the way to go.
All right, so we can do an advertisement for a, well, it's going to be full-time. We'll have to, does that become not labor? We don't have to have a civil service class on that. All right, so we'll do an advertisement for a supervisor or working foreman down there for, I don't know what you want to call
I don't know what I want to call it either. But somebody's going to be able to do the schedule and take care of the monies there. and work as well. So.
So why don't we,
Foreman would probably be the way to go.
okay. We can have personnel committee put together a description for the ad, how's that?
I'm on it.
That too. I did ask Ted to get together a list of his duties and the approximate time and sort of things. So that for interview purposes, we'd have that information.
Okay.
Could we say full-time, how many hours a week is that, 35 hours a week?
Yeah, but I'm trying to think, is that one
Well,
of
the
the
transfer
departments that
station is
doesn't?
open 40 a week,
Yeah, so it would have to be 40 hours a week.
but with that, we offer lunch, don't we?
Yes.
So does that cut it back to $35 if you've got 5 days of lunches?
Personnel committee will work that out.
Okay.
It'll be full-time, whatever the hours are and how that equates to a work day, how's that? We don't need a resolution on that.
To publish in the, do you do a resolution publish in the Post-Star?
Yeah. So somebody want to move that?
I would move that we have an advertisement placed to Post-Star, maybe in the Chronicle, advertising for a working foreman for the transfer station.
And we'll get a description for you, Leanne, shortly.
Salary?
To be determined based on experience.
Can I get a second?
Second.
Thank you.
So we'll have to set that.
All in favor?
Any discussion? All in favor?
Yes.
Opposed, motion carries unanimously. Also under transfer station, I've had an individual who has stopped by my office and called and is very interested in assisting us with the removal of some of our this season's grass clippings and leaves. They don't want the ones that have already become organic matter down there. They want the fresh stuff, and if anybody's been down there recently, that pile is very large. There's not a lot of room. I think it's a great opportunity to give us some breathing room to get more stuff in.
The one the truck has as well.
So
They need somebody to load it.
yeah, so he believes that he can get a couple trucks, maybe more 60-yarders to come in, tractor trailers. He does need someone to load the vehicles. The board is willing to direct our staff to do the loading down there. He can probably get those out within the week or so.
I'd be okay with it. I'm just thinking about like a whole harmless agreement. Should there be an issue with loading?
That's what we normally have.
What's that?
Our guys are loading.
Oh, our guys are doing it fine.
Yeah, they're just pulling them with a truck or loading.
We're under our insurance.
Okay. Then I guess we're okay with that.
Everybody's okay with that? Okay.
Do you need a resolution on that?
I don't think so.
Okay, I just remember them all fucking right here.
Now, and you thought you were all done discussing brush policy down there. Unfortunately, we do have another issue. I had a resident who lives here on corner 197 and 32 that called my office, stopped in twice. Very much wanting to talk with me. I did follow up with him in a phone call and was not happy that he was being charged for his F-350 8x8 box dump truck to dump brush at the transfer station because he's handicapped and has a handicap tag. He said, now if I get out and unload the brush for myself, I don't have to pay for it. If I pull the lever and dump the truck, I gotta pay for it. It's $30. So he wanted to know why we don't allow handicapped individuals to dump for free and why he has to pay if he dumps it and otherwise he doesn't have to pay. So I indicated to him that I'd bring it to the town board for discussion and I would report back to him. So I don't know
Is it a state body back end or is it
So-
a regular pickup truck that he's got dumping bed on because?
So the information he gave me is that it's an F-350 8x8 box. He didn't say what size it is. And he pointed out that, you know, we currently don't charge for a 6x12 trailer. And an 8x8 truck or box is smaller, but you know, I don't know how high the sides are on. And he's most concerned because he's handicapped. He thinks handicapped individuals should not have to pay to dump it. So I don't know what the board's pleasure.
I guess I'm not aware of a truck like that, so I don't really know. I mean, he's got stakes on the side, that's one thing. I think that was one of the issues that came up. Was it a regular pickup with a modified back end?
I have no idea what it
I don't know, it's-
I have an idea what the truck looks like, but I don't, I mean, it's a dump truck, essentially.
And yeah. An 8x8 size bed.
Yeah, I mean, we, as you recall, last time we modified our fee schedule, we were specific saying that utility trailers larger than 6x12 dump trailers, stake body and dump trucks are $30 per load. And then we clarified that passenger vehicles, pickup trucks and small utility trailers not exceeding 6x12, there is no charge. So I guess the question would be, do you want somebody who has a handicap hang tag to have a special class in that category? I guess that's what the question.
I mean, I can understand that.
So we have a handicap exemption for this.
Yes.
Yeah, I mean, I'm okay with that. I don't think we are trying to add more undue hardship on someone that has something that is out of their control. I think that's not the point of this. I mean, quite frankly, we only have one issue. I think that's okay. We can clear it up with refund them, we'll refund them. But we're not running into red flags with everybody in town because we've tried to tighten up our policy at the transfer station. So one scenario that brought to your attention that we can refund, I'm okay with that. You know, I don't see this as this is a bad thing. I mean, there's gonna be situations that come up and we have to use our discretion.
Okay, so you want to do it as a discretionary thing on a as needed basis versus changing the wording to handicap exemption for all.
We can change that right now, but I'm saying this situation hasn't, because it's come to us, it seems to be a one-off situation that we're currently in. So,
And on one hand, I understand, but I'm looking at it and I'm thinking, the whole idea behind this was so that we weren't having issues with the town members and that it was clear to our employees what to expect and what to charge.
you know,
Yeah, and you know, there's a fine line between having a new policy and then having it subject to abuse too. I mean,
and that's
somebody's doing a lot clearer and they have their hang tag, they just keep coming all day.
well,
So,
hopefully the new working form that we have, we discussed this.
right,
The personnel committee talks about some of the scenarios that come. If that person's on site and they can walk up and they are sound mind and body and they're able to walk up to an individual and go, hey, what's going on here? I see why this, why you're bringing this up to our attention. I'm thinking it's gonna be okay. But I think that you do the hang tag, you write it down somewhere, you write it down on our fee schedule, then it's long. I say it like quotes. And then we're gonna come into this other situation where we get a phone call 2 weeks later, go, this one guy came back 15 times with a hang tag, he dumped 15 loads of brush, not grass, brush. So-
That's the thing, I realize why people at the transfer station want things in black and white so they can show people black and white. But I think, there's gotta be some discretion used there. If
totally.
you see a guy coming up with a handicap sticker 16 times a day, he's clearing a lot somewhere, there's a business. And maybe that's where the responsibility of the new working foreman would come in. Because I know the girls don't make it decision. You know, but if we have somebody there who's in charge and who can make that determination. Because recently we're coming in here every month and we're tweaking that thing because we're getting exceptions to the rule. We're getting exceptions to the rule, and every month we're trying to tweak it again. But there could be some common sense and some discretion rules, and hopefully we get to work before that to do that.
And
And help to talk to people who, you know.
that working formula, we don't know who it is yet. I would love to talk about other things on that list. We got kitchen garbage versus non-kitchen garbage in there, but that's a whole other night.
So we can do that, or we can have a policy that somebody with a handicap tag that does get charged for a load can submit to the town for town board action for reimbursement. But I don't know, is that complicating for the clerk?
It's not complicated, it's just more time consuming. I mean, if you have a rule, people just have to follow the rule. You're either gonna, if you have a handicap tag and they have to identify it, you know, it has their driver's license number on it, so you can match it up with the person.
Oh, that's true. They're all there.
So we would just leave it up to the discretion of the.
But thinking about that, the clerks down there would not, can I see your tag, can I see your license, let's compare this. To make sure that this is.
That's the only way you're gonna know.
Yeah.
And if they're not going to do that,
You know, they don't wanna, as clerks, I don't think they wanna be like enforcing the rules, so to speak. It's just kind of like, here we are, and, you know.
well, then they won't know how to work in the office.
Well, I understand that because it saves them the date, you know what I'm saying?
Right. And, you know, it's, the fact that they should have their sticker on the vehicle to signify to the town resident that they got a handicap permit.
How about if we allow the handicap, if the person sees someone use something in the rest of the use, I mean, it's like, you've got the handicaps that you use up your stuff. You start coming back 3 or 4 times a day, but stop it because now we're going to look into it, investigate it, and see what the story is, because you're coming back 3 or 4 times. You're probably not just bringing your regular things and stuff. I don't know.
Can we ask the clerks to just maybe write the license plate number down to see if there's, when it's repeated, because that was in the same clerk, I mean, then maybe it shouldn't be an issue, because I'm assuming, or I'm sure, pretty sure whoever this person is not gonna be a repeat offender, because this would be something we would be hearing over and over and over and over again, right? This is the first we've heard of it. It takes time for people to set their thoughts and their actions into place when they see the rule.
The word spreads through the community, which I doubt.
So we don't have to take action on it tonight. I mean, I would like to refer to transfer station committee. And review it. If you think we need to change policy, we'll bring it up next board meeting. If you're fine with the way it's working, we won't bring it up. How's that?
Okay.
You got it? And that is it for transfer station. Item 6 I have is water department. We have a request from Jesse. I know, I believe the water committee has been working with Jesse on this for a water meter reading software upgrade. This is a proprietary program, and we can only get it from this particular vendor, which is Ferguson Waterworks. This will really bring the town into the 21st century IT-wise when it comes to meter reading. And the quote that I have written here includes annual hosting and setup / training. Excuse me. It also includes Toughbook laptop with AC adapter, and this is considered a sole source purchase requiring only one vendor. As I indicated, this is from Ferguson Waterworks, and the price for that is $10,141.19. This would be distributed, the cost would be distributed across all the water districts, which is account 8310.4. Present balance as of November 30th is $274,394.41. Recommendation is to purchase this device from Ferguson Waterworks.
So moved.
Second.
Any discussion? All in favor?
Well, I just have one. So this comes with one laptop. Would it be beneficial if we had two for each of the water employees?
I'm not sure how the system works. I don't think so.
Right now, we just kind of swap it in and out with the handheld that we have.
Okay.
So I would assume we would do the same thing with the laptop. We would probably leave it in the office, and when they have to do a final rating or they have the regular rooms loaded, then they would just go out with the laptop and read the meters. I don't think it would be a difficult thing to just leave it here, and then whoever happens to be the one going out to read would just grab that laptop and go.
And I think it has apps you link to if you have some sort of small handheld. So it's a program that we need to expand single devices in the future so they can't easily enough.
They also, it'll have to be loaded too, so it's not like you can say, I want to go take this one and go to that, because it would have to be loaded from the data in our office first before they could do that, for like regular readings and things like that.
Okay. Great, understood, thank you.
Any other discussion? Hearing none, all in favor?
Yes.
Opposed, motion carries unanimously. That's the water. Next item on the agenda is item 7. Each year the town budgets for funding to assist the Grant Cottage, which is actually located in the town of Rome. Many people believe it's located in the town of Wilton. That is not the case. This is the place where General Grant, President Grant, spent his last 6 or 7 weeks writing his memoirs. And we have a voucher that has been submitted from their executive director, Stephen Porto, in the same amount that we budgeted for 2020, which is $5,500, and we need authorization to sign the voucher.
So,
Second.
Any discussion? All in favor?
Aye.
Opposed, motion carries unanimously. Today's the 8th. Number 8, I have listed as the part-time code enforcement officer. We did receive, after our canvass, one letter back from an individual. I think all the board members have a copy of the application. I just wanted to see if the personnel committee wanted to interview the individual. If so, you can get some dates to my office,
okay,
and we'll set the interviews up.
I talked with the council member Van Tassel about it.
Okay. And everybody has a copy of that, right?
mm-hmm.
Number 9 is Medicare reimbursement. If you recall, the town has made it a policy, and it's only appropriate from a financial accounting standpoint that we do resolutions authorizing the expenditure of town funds, which we have been doing for a number of years now for our retirees when they reach a certain age. And we have a retiree that has reached the magic number where the town will provide for partial reimbursement of the Medicare for this retiree on the Medicare Advantage health plan. So this is for the retired former Deputy Highway Superintendent Michael Montgomery. So I have a resolution that I'm looking to move, which specifies whereas the town board has authorized the partial reimbursement of Medicare for eligible retirees on the Medicare Advantage health plan, whereas retiree Michael Montgomery enrolled in the Medicare Advantage plan on December 1st, 2020. So be it resolved that the town board hereby authorizes Medicare reimbursement payments for Michael Montgomery in the amount of $289.20 quarterly.
So moved.
Second.
Any discussion? All in favor?
Aye.
Opposed, motion carries unanimously. That takes us to supervisor items, just a few things. I have asked, and I will be submitting Deputy Supervisor Kyle Noonan name for our representative on the advisory youth board at Saratoga County. I think that the director has already reached out with the information.
Yeah, someone sent me an email.
Yeah, so each town appoints a member annually as part of the organizational meeting that takes place at the county first week in January. And so he will be the town's representative, and just want to thank him for taking on that responsibility.
Thanks, John.
Thank you.
Also, I have a flyer for the 2021 annual meeting and training for the Association of Towns registration. It will be online February 14th through 17th, 2021. It's an all virtual educational and networking event. And I have the information if anybody wants the information. I don't know if, well, actually the town board members had already received it. Went to all of our department heads as well. Just will note that the listing of courses that are there for the virtual meeting, it specifies that most courses will be eligible for CTO credit, and there will be 8 CLE lit sessions. There will be no CPE credits. There will be no justice and court clerk training. There will be no building code enforcement credits, and there will be no engineering PDH credits. And I have a listing of all the different sessions. If anybody has any questions, feel free to reach out. And I did receive a request from George Reynolds of Reynolds Road fame family, requested that the sign at the intersection of 32 and 197 be raised. I don't know if you saw it, it's kind of like 6 feet off the ground. Typically those signs are 10 to 12 feet, depending on what kind of signs they are. The problem is there's so many repeated accidents there, and the signs keep getting knocked down. The signs getting shorter and shorter as they put into the ground. Typically, the town is responsible for all road signage where it needs to state highway. However, this is a unique situation. It's both state highways. I reached out to Saratoga County DOT resident engineer. He's making a request that his sign guys will take a look at it and install appropriately if it's their responsibility.
Thank you.
And the last item I have for supervisor items, received a copy of the Capital Region Memories book. It's a pictorial history of the mid-1800s to the 1930s. And it was generously provided to the town by the Parks Bentley, actually the Historical Society here for the town of Moreau. And I'll read the letter. It says, the volunteers of the Historical Society of Moreau and South Glens Falls are proud to present the book Capital Region Memories as a gift to the town of Moreau. There are pictures from the archives at Parks Bentley Place included in the book with acknowledgement of the society. It was an honor to be represented as part of this collection. Sincerely, Nancy Purinton, President of the Historical Society. And so just want to thank her on behalf of the town board and our residents for having that donation. It'll be in my office for a little while if anybody wants to take a look at it, and then we'll probably turn it over to town historian to be cataloged. So if anybody wants it, feel free to stop and take a look. And the last item I have to discuss under supervisor items, we talked at the last board meeting about interested party in taking stand from the wreck. I have another interested party, another developer that has a project that's close to the park that also wants to, is interested in having sand if we're amenable to that. I think everybody was kind of in agreement that, you know, if we got more details on that, It's something we want to look into. So what I would suggest, if the board still wants to do that, because we have interest, that we put together an RFP, see what kind of interest we get on that, and then come back to the board and see if they want to move forward with that. I think as part of the RFP, we may want to have verbiage in there about, you know, doing a survey to lay out the second bowl, make it a project, because we don't want this to be a mining project. We want this to be part of an actual rec project, because I believe, talking with our town engineer, if we're actually building something, it's not considered a mining operation, and therefore you don't need a mining permit. So I guess the question for tonight is, do you want to do an RFP on it? If so, we can have council work on putting an RFP together.
I would say yes. My question, as a project, would also include like an entrance coming in off of Fort River Road?
You could.
Because, you know, I don't like the idea of trucks coming in, you know, off of Jan Avenue by the school. I don't like the idea of them having 12 lights. I think that, you know, having trucks loaded with sand are probably going to be destroying the drive to close down. And that we need a different access point and to plan for an access off of Fort Edward Road that we can be using for access into this potential play area.
Like permanent access, not just construction access.
Correct.
Yeah, I would agree with Councilmember Hogan on that. You know, this is, this kind of came to us, really, we didn't seek it out, now it's in front of us, and I think we're gonna try and look at the best avenue to see if this is something that we can ultimately do want to do, but I'd be willing to put an RFP out. I still am not sold on what, you know, on the whole idea, but I'd like to see what comes back to us and then what the cause and effect here is going to be on the park space. I don't have a problem looking at what the cost would be for building a second bowl down there, if in fact there's another way to, you know, get that sand out of there. I think part of the issue the first time around was, or I say first time, just last meeting, was I looked at it as when the meeting was over that this was a way to build a bowl, but I don't think there's enough need for all of that sand. We don't know what people need. There's so much sand that has to be removed to make a bowl that I don't think that when it came to us last time, you know, without knowing the volume need to be removed, I thought, oh great, it's going to help us build a bowl. But the reality here, I don't think one developer's needs or one business's needs can do all of that and need all that sand, so we'd be leaving a hole in the ground. And you know, if we're working towards it, that's one thing. But I'd certainly be willing to look at information on an RFP to figure out where that puts us, and make another, you know, have another discussion about it down the road. Because I certainly don't want damage to the road. I don't want a half-completed hole in the ground in the middle of our rec park. I know it's not in the middle of a rec park, but it will be if we have an entrance going out that way. So it's just things that and then if we dig the hole in the wrong spot, did we mess up the opportunity to do something with some of that land down the road? So I would be interested to hear what some of these people need and what they want to do. Well, based on the survey. Yeah,
the other thing is too, we don't have to dig a bowl as deep as the one that's there. I think that one's 22 feet down from the top of it. Yeah. That's a good amount down, because of the project that we're part of. I mean, you can do based on the volume that you want to come out, you can do
at some point, you could get 6 feet.
6 feet, you know, just so that you have spectators still have that side as their bleacher, and it's just not deep. Which is fine. Again, I would love to just see maybe the survey, the space needed, right? With over, I mean, and I don't have a problem looking into it, and I think it's a great way to go forward as opposed to having someone come in and dig it, or
for us and then figure out what to do with all that stuff. And, you know, if we're able to make some revenue off of the sand or cut our costs down, I think that's a good idea. I would just like to, you know, see more when it comes in front of me.
Yeah, and we've talked, I mean, we know that, you know, we, from a safety stand, public safety standpoint, to have another point of egress, access and egress is critical at key times when we have tournaments down there. I mean, there's only 2 ways in and out right now. To have a third going down a totally different road is an excellent idea from the standpoint of public safety. Getting in and out of there, you know, what that's going to entail. You know, it's a good distance to get out to Forever Road. Not impossible. You know, so we can have that part of RFP if you want. And we don't have to take action on RFP. We get the proposals, but I don't do anything with it. You know?
Right. You know, I'm perfectly for expanding our recreation opportunities down there. Yes, yeah, we've done that. I think we should look at anything to housing. If we can get that stuff removed and make some money on it, cut down the cost of moving down there, I'm all for it. Recently, I received an email, I think everybody else did, from a concerned resident about permits that might be necessary, legal things that might be done. I would just like to think that we would cross all our T's, dot all our I's, have legal guidance through this process. Just so we are, then, you know, there was a problem about mining permits and stuff like that. I don't know what's necessary or legal. I just make sure that we have all that done. That's all. Because I'm all for it. I think it's you know, it's a win-win situation. We can find somebody who wants to take that stuff out. We want it. You can tell somebody to take it out and pay to take it out. Maybe put a road in for us that would be, you know, we can negotiate these things. And I think it's we to our advantage to go forward. I want to just make sure we're then, you know, guidelines set up by any laws or regulations or, you know, things of that sort. So
yeah, we're going to follow all environmental.
That's my only concern.
Yes, I mean, we have, I can tell you some listens I've been supervisor, we have an excellent track record, making sure.
That's my main concern.
But yeah, those are good points. So council, do you have enough info to at least draft an RFP or not? I can work with you on that.
Yeah, you said a whole lot there. It turned into an RFP for basically, now it's an RFP basically for an engineered goal or an RFP. So we'll talk about.
Yeah, so I have the plans for the other big number, not doing that.
Right.
I do have a file on that. Rourke did the surveying on that particular project.
Right.
You know, we do need to look at the survey map and see where we want the interest to come in. Maybe we do the RFP as a part A, part B, either do it all together or part 1 or part 2 of it.
Yeah, and we'll have to talk about it. If you're looking at it as a project, then you're going to need to have engineer drawings. Are you asking for an RFP for an engineer to submit a design plan?
Yeah.
It's a lot larger than what it first came out to.
Yeah. So
I agree, by the way. I think
so if the rec committee wants to come up with some ideas.
And let me know what you want to put in. Great, I'm happy to meet with you.
I'm not a rec committee, but I would support the rec.
Well, I was trying to ask yeah, which, you know, I have about that properties and looking at that. I took a drive down for everyone with an in the park. You know, it looks like you basically would have to bring. It looked like there was, and I'm going to stop for just a moment. How are we doing on the acquisition of the property that we just agreed to?
Moving forward, we were talking to the title company today. They're going to have a title for us next week. We're having to sign.
So with that in mind, one of the better spots to access on the border probably is on that property.
Yeah.
Versus the property that we currently own down there. Because it looked like it was too marshy down there.
Yeah.
So we moved it back closer to Bluebird Road. that would be a better spot to access that property.
And that's why we need to have a conversation as to what the board actually wants before we can draft an RFP, because I've heard a lot of things. I don't know where you're going.
Why don't we, I don't want to have, it's coming with the holidays and everything, I don't really want to have more meetings than we need, but why don't we start with have the rec committee just review the topographical maps. We know what BOCES is. They cleared a lot of land down there over the years. So we have a lot of open space for everyone to do. Maybe look at conceptually where you want, if you want to do both, where it would go, and then maybe look at the map, and then we would come back and be more specific on where we want to go. Do we want to do the road? Because I know one developer is willing to probably do the road, but they're not going to pay for the sand, and so you got to figure out what you want to do.
No, I get it, and I did do that. Somebody came in and said, you know what, we can build a road in here that, we can, the base or a road, and we could, I'd be happy to have them take the sand.
And the other thing is, we're trucking sand from another municipality for a highway garage.
Which, yeah.
And paying for it.
But was, right, we are. And it's just what I've been told is this sand is not adequate for what was used.
I've heard that.
I'm not the expert on that. But.
So what do you like?
So the rec committee is you and Ellen?
Yes.
Okay, let's get a call in the next couple of days and figure out what we want to do. That work?
I'll do what I can.
Okay, well, whenever, it doesn't matter to me, you tell me, I'm Monday.
No, that's fine.
Okay.
I'm glad we're going this route though. I feel like a lot of the conversation last week was we were up against a deadline, to kind of work alongside someone who had a need. And unfortunately, I don't think we can work that way, or we can rush things or work faster than really what we're comfortable doing for what's the right way of doing. So I think maybe we're on a better plan to look at what those resources down there can offer. And this should be a better conversation to try and get something done before the first of the year. And then it's, so I'm okay with that.
And, we had a rec master plan committee a couple of years ago that worked to come up with long-term goals.
I think the second goal was in there.
I think it was.
Yeah.
Dust that off. And anyway,
Yeah.
so rec committee will start on and provide a little bit of direction. We might have to do a workshop down the road, especially if we're laying out roads and stuff like that. But we'll start there. How's that? Committee reports. Anybody have a committee report?
Yeah, right.
Beyond that.
Yeah, so with the rec, the last pouring should be for concrete for the universal playground, splash pad, sidewalk, should be on Thursday morning. I think the rate report for tomorrow was supposed to be snowing in the morning. They want to push it off. I'm okay with that. So the concrete should all be poured by Thursday. Architects would actually like to do a test on this. I'm not opposed to it. I'd like to see it working, but I'm looking at the weather reports and I'm not sure where it would be fit in.
Well, I was down there today and they asked me if I wanted to bring my swimming trunks and be part of the test. I said, the poor maybe in the summer.
Yeah, if we get 60 degrees in January, maybe.
Yeah. So, oh no, we will test it before payment goes out the door.
That was my thought.
Yeah.
That was my thought.
All right, thank you.
Transfer station, we know about that. I'm good.
Okay. Any other committee?
Just want to touch on the rec department. With the adaptive playground and the splash pad and everything. So read an article in the paper. And it got me thinking, because I knew there was a backstory to the beginning of this project. And so I reached out to some people and I found out that 2 young men started the idea for this event. I got their names, so I just want to publicly thank them. The 2 young men, Noah Jacobs and Logan Mahoney, I guess came up with the idea. And it just morphed, it just really took off. I know Sandy Mahoney, who was the prior rec director, kind of picked up on it and formed some committees and stuff. And it was just interesting to see the way that the whole thing morphed. You set out some committees of residents and up with ideas and brought them to the board. And the board jumped on board and followed this thing through. But I thought it was just it was a great story. And I just want to thank the young man that brought that idea up, Sandy, for all the hard work she did. Terry Warren for getting us some funding for it.
Well, we have a commitment for it.
What's that?
We have a commitment. We haven't gotten it.
Checks in the mail, but I mean, we were able to secure that too. So I mean, there were a lot of people involved in it, and, especially like I say, these young men who brought that thing up. I'd like to thank them and everybody involved in it, because it's quite an accomplishment to have that playground down there. So,
Yeah,
But I would think that we would have them down when we have an official opening. I think we would make sure we have.
Absolutely.
I know Kerry Warner wants to be a part of that, and absolutely.
Certainly has to that recreation.
Yeah.
And I think Peter, his crew down there too, they've been working very hard, especially lately to get the thing done before we get for the stuff. So thank you to his help down there too, for doing a great job.
Anything else on the committee? I do need a brief executive session, but before I go there, any other business for this? All right, so hearing none, I'll need a brief executive session to discuss an unnamed town employee or employees' work history. Yes. Somebody would like to move that.
So moved.
All in favor? Opposed, motion carries. So we'll go into, we'll have to shut us down for executive session, and shouldn't be too long.
All right, so we're gonna pause. Audio is now up.
Well said. So I'd like to report that we're coming out of executive session. Do we need a motion to do that?
Come out.
Yeah, and I will report for the record that no action was taken in executive session. We have no other business. I'll entertain a motion to adjourn.
Second.
To adjourn.
Second.
All in favor?
Aye.
Opposed? Motion carries. Thank you, everyone. Appreciate everybody who tuned in. And we'll see you all next time.
All right, give me 1 second to turn it off.